I think I can remember 10 or 15 consecutive. I am appearing on behalf of resolution number 2 and 3. This ASIM is the youngest counsel and he has been suffering from fracture on her leg. Now they been died for full
7 days time.
December.
7 days time to change your counsel. 2015 back. Past is the key. The request
Two and
is then adjourned to be listed again on the 1st of November.
the one of the list. I have summoned the entire team by the record. We had 3 rounds of deliberation, but things are not straight and it appears in the repetition. Now, the first aspect of the matter, because they are claiming under their predecessor in interest late Bhagavan Chandra Sharma. He was the original partner. And to that extent, his lordship comes to his lordship may be pleased to take up the petition that the records are of the ceiling case are not available. This is the position because that pertains to the year my lord 1976. And in fact, during the instant proceeding, time and again we have been taking time of the honorable court to enabling us to file a comprehensive affidavit. Nonetheless, we have filed one affidavit on the present status of the matter. Now, page 91 also will kindly see. Also got it, madam. Page 91. Page 91, this is a minor death certificate of cremation issued by the Kamakya Devotional Board. And here it says, my lord, that Sri Bhagavan Chandra Sharma, ages so who died on 1978, was cremated in the Kamakya ground on 12/8/1978. And in the preceding page, at page 90, Lordship will see, page 90, this is the handing over, taking over, after being declared as killing. দখল সন্ধি পুয়া প্ৰমাণপত্ৰ কালেক্টৰ মহোদয়ৰ 81 তাৰিখৰ মেমো নম্বৰ এবং 60 বাবে filling উত্তৰত now Lordship will kindly mark here, see in the second line, they say that there is a sealing case under the name and style of 372 of 1976. Now this 372 is overwritten. This 372 is overwritten. Down below, Lordship will find 384 of 74. Then, অধিগ্ৰহণ হোৱা তফসিল বৰ্ণিত মাটি দখল সন্ধি বুদ্ধি পাই ছবি কৰিলে। Lordship will see in the signature column, right hand side. Second person, see Bhagavan, the first person, see Bhagavan Chandra Sharma. Now, if that person has died in the year 1978, how can we sign this document in the year 1981? To that extent, The district administration had made a request. They approached the Kamakya Devotional Board.
Now, what is this document?
With regard to handing over, taking over.
Taking over, taking over.
Handing over, taking over.
Right?
By my lord, the person's name here, that is Bhagavan Chandra Sharma,
Who has prepared this?
this is also not known.
So what is the value of this document?
You know, this document is that they are relying on this document. So they are relying on the count that my lord, the ceiling, there was a ceiling proceeding. And in that ceiling proceeding, my lord, the surplus land was delivered by them to the government.
Let me just clarify, that's a precise allegation. They're saying that we never handed over possession. And this particular document at page 90 is false. And to substantiate that, we have page 90.
This is basic, but my lord, the fact remains.
Or you are proving it?
No, I am not approving.
Obviously, the fact that if the person has died in the year 90, his document is not a bit.
Yes.
You are also supporting. That means he's also case. Therefore, this document is fake. It's therefore used to this document.
Now, madam, why I am making this submission? We are relying on a ceiling case that is 372 of 76. We say that there was no ceiling case, namely 372 of 76, but there was a ceiling case 375 and 374. So 372 does not exist at all. Under which they are
Then under what circumstances? Who initiated proceedings under the fixation of lands?
we initiated proceeding, therefore, Lordship will now kindly see, my lord, page 87B. Page 87B. 87B. Before that, Lordship may kindly come to page 74. Page 74. Again, I am submitting. My alternatives are limited to the extent that I do not have access to the original ceiling case record. Now, page 74 is Lordship says, my lord, that law, that note law, page 74, that hard paragraph, Lordship. Wow, there it is, Lordship. Can you see? 376. 376 of 76 number ceiling case, 7 feet Haramate, collector Mohudaya, 22/6/1976 তারিখৰ হুকুম মতে 9 নম্বৰ নিষ্ক্ৰিয়াছ খেৰাজ পট্টাই সমুদায় 1/8 লেচা মাটি চিলিং অধিগ্ৰহণৰ বাবে চিলিঙৰ আইন মতে অধিগ্ৰহণ হোৱাত চৰকাৰী বনবস্তিৰ পৰা বাদ দি চৰকাৰী কৰা হয়। Now it is 376. 376. Type copy available at page 87. Now kindly see the type copy.
You return.
Return 41. I'm so sorry, madam. 41. Page 41. Page 41. I will come to 87. Page 41. This is the type copy. Translation. There Lordship will kindly see go the third paragraph. As per order of collector passed on 27 under section 70 of the ceiling case number 370. Now this where the problem is created. 372. If Lordship compares page 41 with page 74, the error is apparent.
And
In FA 74,
so you have the records of 76, 376.
nothing is available. That is the difficulty. No record because after bifurcation,
Isn't it required?
I don't,
Where is the final state?
that is also not available.
If it is not available, then how government can take over the rights of somebody? That is a document which has to be maintained.
So it has to be, but it is since it is not available, therefore my lord, I am making this submission.
No, you can't make any submission because unless the final statement is not there, there's nothing. Means it is not a completion of the 7 proceedings. Tell me, how do you complete the 7 proceedings? With a 7-5 notification, final statement. An order may be passed under 7-3, but that on the basis thereof, it is not finalized. The finalization will only happen with the final statement being passed.
Now the statement
Yes,
was at page 87B.
Let us see, wait, the provisions. I think that is, I am not wrong, that is the law.
Yes, statement has to be approved by the government.
So that statement is the most important thing.
That is also not available.
If it is not available, then how? If it is the mandate that it has to be taken into account. The king lies against there only. The final statement, you see 7-3, the draft statement shall then be made final in terms of a final orders passed under the preceding subsection and the collector shall sign it and affix the date. So it will be a draft statement with an order of the collector. Notwithstanding anything in the next subsection with the effect from the date on which the file is signed by the collector under the proceedings of all rights, interest of a person whose land has shown as excess in such statement shall stand transferred and vest in the government free from all encumbrances created by person. And no person shall be entitled. Under Iman, above shall be published in the same manner in which the draft statement is to be published under so and so. So unless the final statement with effect from the date on which the final statement is signed by the collector under the preceding subsection, all rights. I think there's some mistake here. 7-4.
Okay, all rights cited in.
No, kindly see. 7-3 says the draft statement shall then be made final in terms of the final orders passed under the preceding subsection. The collector shall sign it and affix the date. So 7-3, there is a requirement of a final statement. Once the final statement, then the land stands transferred. But without the final statement, how can a land stand transferred?
Statement, because it is on the basis of final statement, the excess area is called out.
No, the vesting happens.
But the condition
No. Most important is the vesting. The rights which are there of a person stands vested by operation of law with the finance. And without the vesting, the government has no business.
for prior to sale, because one has to ascertain the excess area. Now that is to be found out from the statement to be prepared under section 7. Now for that reason, they have annexed one document which the people find at page 87B of the requisition.
That's the return.
Because whatever it is, let us see this is a totally unsigned document. So that here lies our predecessor. Since the original records are not available.
So this is a document where there is some saying that as the collector, this is what? This must be the certified copy.
Certified copy.
Then why are these Sadar, SDA, Muzadar, Pattadar, what are these things?
It has been relied upon by the petitioners. They will have to tell us before this honorable court how they have got this statement. Because it is totally unsigned. And the type copy lordship will find in the preceding pages. It starts from page 87. Kindly see page 87. Page 87 is the type copy. Type copy of relevant portion of return. Page 87 is the type copy. And they want to project before the honorable court that page 87 is.
Now, what is this? 88, page 88. Seen and peruse the case record, whereas the final statement have been issued. So this is the compliance to 7.3. And excess land stands transferred to the government. Let STC submit a report on taking over of possession.
Now, this is with regard to ceiling case number 384.
Yes, 380.
They are relying on ceiling case number 372. That is why I have drawn lordship attention to page 41 and 74. Their plain and simple cases with legal limited to my lord, ceiling case number 372 of 73. And in our affidavit, in the one and the only affidavit which we have filed recently, we have stated that there was no second case. As 72, as has been alleged by
So
them.
what is this order then?
So
At page 88.
page 88 is with regard to some other ceiling cases.
There's
where-
some Hare Krishna Sharma. Who is he?
One of my predecessors.
So they have got many amount of land, my lord, in that area. Now we are concerned with ceiling case number 372 of 76.
374.
So they are relying on 372. They say
Now, what is this page 85?
page 85.
This is in respect to 384.
For
What are these orders?
original signature of other correct
Copy of
performer.
Ramabandi, Sri Sharma has more than 75 draft statements is published. Well, reminded, now this is again why he has mentioned about 372.
372, they have stated
No, Mr. Dekar,
Well, I'll
tell
just-
me one thing, page 84 is in respect to some case number 372/76. And then page 85, again it mentions about the case of 384/70.
That is that is another anomaly that I'm describing. I need not explain this document. What happened was, we found in the Jamabati that the land is sold to the account. We had no clue about the acquisition. Therefore, we preferred RTI application. That those meetings are already there. After those RTI applications were filed, at page 76, my lord, the Deputy Secretary to the Government of Assam Revenue had provided these documents. So these are not my documents, these are provided under the RTI Act. Now, from these RTI records, my lord, we found two things. That there were strangely two land acquisition cases registered, 384 and 372. There was no, we were not provided with any records of 384 and 372. Now, that order whereby I was allowed to retain 310 bighas, allowed to retain 250 bighas, was passed, previously passed in both the cases, my lord. Page 81. This is passed in 372 of 86, my lord.
76.
76, my lord. And then again at page 986, my lord. That's
Let us read that portion of that order.
Could I read the translate?
Page 82,
81.
page 82 or 81.
81.
Where is the translated version?
Translated version at page 80.
82.
88.
Report of the Commonwealth. So this happened in which case?
372, and at page 85, your lordship will find the order sheet of 384. Again, the document which is, they had provided. That's the order sheet of 384 of 74. And here also similar order is passed at 86.
But here there is no dark number.
No,
Page 80
80.
does not say anything about any dark
No,
number.
no, it doesn't say. It doesn't. It doesn't say.
Kindly see on top, page 81.
81 is the Gusor ceiling Gusor number 370. Number of
Indrajit Tarikot ceiling Gusor number 372. Yeah, hukum. So here you are allowed to keep 250
250.
out of 560.
Yes. Then
Then-
at page 85, they had also provided some order sheet of 384. 85 as your lordship said. On the top, 384. Now, on a part of this order sheet at page 86, my lord, 19676. This is the same order. Kamalpur, so and so.
This is the order. But this is passed in 372 oblique 76.
And
It's the
also-
same order in 384 also.
384. Now, Jomabandi again strangely refers to case number 375. And then their affidavit also, they come and say at times 374, at times 372. So we don't know for certain how and in which particular case they had done that. In fact, that's part of my,
Then you file an appeal under 76.
I filed an appeal under 7.
Now, this is for final statement on the year without showing during the required. When did you file this?
I filed it before the minister.
Here, what our order has been passed?
No order was passed. Well, initially we approached the High Court and eventually it was held that my petition is time barred.
And that is why you have come.
Then, my lord, I filed a review, my lord. Then in that review, they admitted all the anomalies. They admitted all the anomalies. They admitted that there is no publication of final statement, that there is no compensation.
Where?
That review order at page 118.
Isn't?
18 onwards. 118. Now, at page 121, your lordship will find the relevant findings.
Page 181, the last but second paragraph, possibility. Last but second paragraph. Well, towards the latter part of that paragraph, there is no record in the concerned LA proceeding, namely LA case number 372 of 76, to prove the copy of the final statement, to prove that the copy of final statement was published in the office of DC or SDC or Muzadar. Neither there was any record to suggest that the final statement was served upon the portaders as stipulated by the Act. And the finding, lordship will find at page 124. The conclusion.
Now, this order which have been passed by the
Commissioner Secretary, Revenue and Disaster.
This is by the government department.
Was not at page 125.
copy of the it is justified and in the petition to hold the orders of the collector. It is showing. So this is the order which is passed now on the
In
76.
No, no.
76.
In 76, firstly it was rejected on the,
But when it is reviewed, so it is an order on the 76.
76. But then at page 125 for a moment, 125 again, the file then landed in the desk of the additional petitioner.
I order the thing showing to the petition filed by disposing.
Though some irregularities was alleged to be done in making the order of the collector in this, and if it is proved to be positive, at this stage does not carry any legal backing to reopen the.
But what order is this? 125. Under what power?
Alert, after this review, alert, this order was passed.
No, this order has no basis because that order cannot be passed. How can this order be passed at one? Now against this you have come.
Yes.
That is, which never had been. Oh, yes, but if there is no final statement, get back in.
Alert, broadly,
Thereupon lies upon the revenue to do whatever campaigning they.
Now, this affidavit is not to be accepted.
I'm not going to look. First of all, what have you done in respect to that order passed by the Commissioner and Secretary Revenue Department? This is an order under 7.6. So if it is an order under 7.6, how can you get rid of that order?
The tenor of the order is that matter it is to be revisited since the records were found faulty. And there are findings by the government. I cannot comment beyond the record in my submission. Then, now, it was not done because of the fact matter that nothing was available. So we have to have some endorsement to initiate the proceeding again. Afresh.
No, but how can the traditional certificate thereupon be?
Another defining, they are confined only to pilot this 124. What the document in 124, says 124. This is the sum and substance of
So the final statement is.
final statement. Therefore, what is stated, madam? In my opinion, in the so-and-so order sheet of alert case number, we have seen some order sheet of alert case number, which we now say that it is non-existent. Nonetheless, madam, the record says, madam, order sheet of alert case number and also the final statement are irregular, faulty, and deficient due to no fulfillment of provision of the act. This is the admitted position. I cannot comment beyond this. Accordingly, the collector may be directed to give hearing to the petitioners to consider the objection petition for and review the order based on the hearing of petition the appeal petition enumerating instances of irregularities and illegalities. So now this was passed, my lord, in the year 2014. After 2014, the authorities, my lord, could not initiate any proceeding in person before this order because of the fact that nothing, no record was available. That is the predicament. Had I have any my lord, I could have made so many submissions.
I know, but then also what to do? Its order has become final. And now its order being final means there is no final statement.
No final statement.
But therefore, the question is, if there is no final statement, there is no vesting.
Now,
there is no vesting. So therefore, the land reverts back to them.
but now,
So the only way which I find is to carry out a denovo,
carry out a denovo, but then for a moment is not
taking into account what existed then.
now.
That is the only way.
That is the only way. At the end of the day, now, my lord, the admitted position as on today,
Because the law has not changed.
everything
Still, it is 50 because
But if one time, whatever is the question of fact, now they will have an opportunity to agitate again before the minor collector. If possible, disposing this writ application with a direction to the collector to again initiate a test proceeding, then they will have every opportunity of hearing raise their objections under the scheme of the Act, 1956 Act. Now, the difficulty remains is that, my lord, by passage of time, if my lord, so far as this 150 figure is concerned, which they are now seeking a return, is being occupied by so many persons. And today,
occupied is different. Granting of rights by the state is different. Occupied, he has to vacate it.
So they said,
But he has to get it vacated. But the fact that if you have conferred rights, you like to them.
therefore, this person who are now in occupation in this 158 bigha, this person, the third person, they have by now acquired the status of minor settlement holders. So they have been settled because it is.
So you have settled it.
Let me finish my
So
submission.
if you have settled it, then you have to compensate them.
That is what I was about to submit, madam. Now, my lord, in our affidavit, we have clearly spelled it, my lord. If lordship takes up our affidavit for a moment, my lord, page 240. At paragraph 4, my lord, we have spelled it that the so many persons are now in occupation, and we have given a comprehensive.
Occupation is different, Mr. Kaupigan. Occupation is different. There are a lot of people who will be in occupation of government land.
Correct, absolutely correct.
I'm only concerned whether government has created rights in the field.
Yes, whether the provisions of the Ceiling Act was followed or not. If it is not followed, everything finished, you start again. I know, my lord. But then again, my lord, why I'm making this submission? Because from day one, it is the submission forthcoming from their side that they are in occupation of this 158 figure. They are still in occupation of 158 figure. And I suppose, my lord, I think to reply here. And our affidavit, there is no reply by them. So, other persons are in occupation. They say they are in occupation. We say that no. These are the persons who are in occupation. We have given a list, everything. Documented. How many was left?
Then give a direct answer. How?
How much?
They may have been a trespasser, they may be occupying in the government land. It's a different thing. But did you create any right? That is the answer question I'm putting. Give me an answer. Did government create any right in favor of those persons?
Now, my lord, these persons were done, my lord. They have came into occupation, my lord, on the strength of, my lord, order passed in ceiling case number 375 or 76.
And that goes,
So they are in 372.
whatever may be, as of now, the order by which land has been, as there is no final statement in 384
And 370.
and 376. 372. 372 and 384, there are no final order statements. So therefore, there is no vesting.
No, vesting.
Now, if the government has created any rights upon them, the government could not have created.
Yes. Now,
Because the land, if there is no vesting, the government could not.
absolutely right.
Now, under such circumstances, if the government has created, those have become bad.
So this is correct, but the difference lies in the fact that my lord, which is my lord, the ceiling case numbers. They are limiting their case to ceiling case number 372. In between somehow by the 384 has stepped up. In our affidavit, we have clearly spelled out that these persons have came into occupations. Now, the settlement has been done in part and parcels of land, in parcels of orders passed in ceiling case number
So
375.
tomorrow, are you going to say that all the land from your land, the government can make a ceiling, make a settlement? No, there are rights. These are rights which are there. Even in the recent constitution, 7 judges bench also, the Supreme Court has made it very clear that these are rights which cannot be taken away without due process. The only due process or vesting would have been possible as per the fixation of Land Ceiling Act, where there is no final statement out there, it has been held by your own department to be irregular. Thereupon, if you are doing anything after 2014, then take it from those, whoever has settled, get the money from those officers and pay them. Yesterday, the Supreme Court has given a very beautiful judgment that any demolition carried out and loss felt upon it need not be paid by the state government. It has to be paid by the officers. Now, whoever has given the settlement, including if there is an endorsement from the revenue minister, get it.
Now, here. 372 irregularity. They are claiming their rights under 372 of 76. in our affidavit, we have stated that by passage of time, the other persons have been granted settlement over this 188 acres of land. In pursuance of ceiling case number 375, 372, 375, 384. Now, these persons have come into occupation of this 188 acres. In pursuance of order first 375. This is not the list before the honorable court. They are limiting their test to 372. 372 irregular it is immediately.
375 final statement.
Why not?
Show me 375 final statement by which the rights have flowed upon you. Show me that their lands have been taken under 375. See that document.
Because at paragraph 5, why not at
My case is Article 300A, my right to property, whether it has been taken out without a permit. Well, I am not relying on a particular ceiling case. I inquired before the authority. They said it is as per 372 and 380. Job only says it's 375. In their affidavit, they say it could be 375 at places, 372 at. Now it is for them to show that
Sir,
somewhere-
the ceiling records are not available.
Yeah.
Now, in the
Where is the final statement? 375.
not available.
Where to go?
Now, in the record of
I don't know. These records have no value. You don't do it. you don't want to do it. Your right can only flow on the basis of a document. Then are you going to admit? Let us take the then we say that anybody say, any person says that I had some right but I lost all these documents. The revenue department will believe it. It was statement of by an affidavit. Then it will help us in all other cases. Everybody will come up. But the government can say that we don't have any recording where you are required to maintain. And that is the document on which the title transfers. Don't have it consent.
paragraph 5 of our affidavit.
And that has been set aside. And finally show that 375, this land of these dogs belonging to the petitioner were transferred to the state. Up there, come up with 375. Cannot order it. First of all, this order is there. Secondly, you don't have any. So under such the return back the land. Else, compensate them by making a notional acquired add-on 2013.
Otherwise, one can relate the petitioners and direct the connector to start a deal of a proceeding. Because they are relying on the documents that says 124.
Sir, have to also take note of the moment you ask for de novo proceeding. Yes, he is entitled to 250 times. Which they can have taking into account this 5 families were taken. So they said it is 6 families, they have given 5 families. So if it is a de novo, then the 6 family comes. So the
Whatever it is, it will be limited only to 250 because.
that person did not take the 6th one. You see that order. It was set aside, 1906, 1926, which was set aside. There was a specific thing that we have 6 branches, but taking into account only 5 persons were names were mutated. As such, it was held that it is 5%. And as such, 50 figures were given to each. Under such circumstances, it became 250. Now with the 6%, which they are going to use,
So they will.
And in fact, Patta 9 would be exhausted then. Then Patta 9 would be exhausted because it has only 180 victims. Then if they start de novo, they'll have to again give me from another patta, which I'm not claiming at patta number 3. Even if we take it to be 250, then also I'm entitled
He's
to
asking for 180.
180.
Therefore,
Gave you a and by the time the breach is the nearer the breach completion comes, the price will go.
compensation of course will be calculated under the scheme of the 56 Act, madam.
Huh?
56 Act.
Compensation? How?
The scheme provides, madam.
Show me that. How it is possible? For the retainable land, are you saying that compensation is for the 56? No, there's no provision to that effect. It is only in respect to the other land where the acquisition has been done, there you are going to pay as per the compensation. Only for the acquired, because then you are paying some amount as per the revenue rates. The revenue means how much you pay the revenue. That is. Let us, I think, wait till the inauguration made to the reach. Then ask. There's no instruction business out here. What instruction? Nothing is there. With those persons coming also, they can't bring anything.
Right,
So 375 goes, 376 goes, 384 goes. So no rights vest in any land, including a single parcel of land belonging to the petitioner on the basis of the seal. So you are therefore to return back the land. Why should I ask for de novo? De novo is your business.
So return back the land, they will have to, madam, because it will be, madam, verification of the records. Why?
You have to acquire.
Therefore, if a de novo proceeding is allowed to start, the de novo proceeding, then authority and the petitioner, they will lay their claim on the strength of the record.
But lay the claim, whatever may be, they are entitled to 250.
Because now we have it will be nullified as if nothing has happened. So it will start again. As if nothing has happened, but by effects of time, by passage of time, the land parted portions of land which they say that belong to them on the strength of record. On the strength of record, some other persons have kept it. Now, if no city case has ever taken place in accordance with law, then that is an allegation. So therefore, they retain the character of the patadar. They will have to prove their genealogy before the authority. And the authority, once satisfied on the strength of the record, that yes, they were initially in the linkage that this I have done from given to my daughter. That yes, they were the linkage.
No, we set aside the entire acquisition, the sealing case. All orders pass in 375, 376 and 380.
So this
All these things. So you are bringing 375 without anything. So unless, because of the affidavit, we have to set it back. Because otherwise tomorrow again you will come up that we have done 375 and the court did not touch 375. So we set aside 375, 376 and 384. And thereupon he becomes the owner. Once he becomes the owner, any rights conferred by the state upon any person becomes a nullity. The state had no business to do so. Thereupon the government thinks, yes, we are going to initiate a de novo proceedings or sealing. Well, we go to do this. If you don't do, and we ask only the thing to that effect, and they can find suits and all to be done. I think this is the most simplest. Set aside everything.
Now, setting aside, if I may put it this way, madam, setting aside all the alleged orders in relation to their land, because it doesn't say,
You bring in 375.
therefore,
So 375, 372 and 384.
so we bring in 375 because they have limited their claim to 370.
Okay, you make a statement that 375 had nothing to do with their land.
What is spelled out in our affidavit? Can we-
No, are you saying that 375 had nothing to do? with their land. No, because he is not saying anything about 375. It is you who is saying about 375. Nobody is saying about Mr. Decker is very clear. You, from making RTI, it is you who have informed us that on the basis of 372 and 384, you have taken my lands. And have given all these lands to everybody or whatever maybe you have taken all this. You have no land. And you have, in fact, you say that, okay, I don't require 3, but kindly give it to me on 9. And that was also allowed or something you said, no?
We had made that proposal, madam, but eventually because of the petitioner chief secretary order,
So therefore, whatever happens in your case, it is your.
Because they are limiting their rights on the strength of the part and parcels of land owned and not settled with their petition signing. That is the analogy.
Have you denied their right? You denied their right.
So not specifically in our affidavit. We say that
No, not for. You see, forget about specifically and not specifically. Have you denied? Don't come up with this.
thing on our part is that the records are not available.
You're not concerned with records. If your basic doc, you may not have the proceedings. Very well, you don't have it. But you have to maintain the finals.
It's not a- from the government order, also nothing was available in that.
You don't have the final statement by which there is a vesting upon the state.
Department of Law is in that.
Well, let me dictate it. Mr. B.D. Decker, the learned counsel is hearing on behalf. Yes.
I also
For what?
treatment
What business do you have?
agency under the contract.
Very well. You are the tenant under him, you become a tenant. You apply under the tenancy act or whatever may be.
Tenancy, they may apply in accordance to it.
Why should I? It is not your petition. Apply. 23 is there.
That will be but the tenancy right may be requirement by the tenant. That may be one of them.
Don't complicate this matter. It's a very simple matter. We gave the government funds to the government paid. Mr. B.T. Decker, the learned counsel, is hearing on behalf of the petition. Mr. Arbor Pujari and Mr. A. Bhattacharjee appears on behalf of the Revenue Department of the Government of Assam. And Ms. Yuda, the learned additional senior government advocate, appears on behalf of the on number 1, 4, and 5. The petitioner herein have approached this court seeking a direction, seeking a writ in the nature of certiorari for setting aside the final statement passed in sealing case number 372/1976, the order dated 26/2013 passed by the commissioner and secretary. Why are we asking for setting aside that?
but that was the initial order, madam, where they said time barred.
Oh,
After the
but that no longer remains.
The only thing was that in the review order, madam, there was please approve. There was a request for approval, and the additional chief secretary thereafter passed that order at 124.
For rejecting it. The order dated 26/2013 passed by the commissioner and secretary, Revenue and Disaster Management Department. Simple. The order dated 19/1/2015 passed by the respondent number, passed by the additional chief secretary, no? Yes. Government of Assam, rejecting the application for the review. as well as the order dated 31/12/2019 passed by the Deputy Secretary of the Additional Secretary. That is the respondent number 3, rejecting the applications filed by the petitioner on 26/4/2019 and 26/6/2019. Further to that, the petitioner have also sought for a direction upon the respondent authorities to forthwith release the land measuring 158 bighas 4 katha 8 lechas covered by NK Patta number 9 of village needs Sindhuri Gopa under Moza Sila Sindhuri Gopa in the district of Kamrup Assam. From the materials on report, it reads we appreciate that for the purpose of adjudication of the instant petition, this court finds it relevant to take note of the facts leading to the filing of the instant petition. The petitioner herein are the legal representatives of the original Pattada, being namely Bhagavan Das, late Bhagavan Das, late Hare Krishna Das, late Golok Sharma, late Suryakanta Sharma, Bhagavan Sharma, late Hare Krishna Sharma, late Golok Sharma, late Suryakanta Sharma, and late Chandrakanta Sharma. Their predecessor in interest held various plots of land, including lands in NK Patta number 2, comprising of 7 bighas 2 katha 8 lechas of village Upatare, and NK Patta number 3, comprising of 394 bighas 0 katha 2 lechas under village Bon Moza. In addition to that, the petitioners, the predecessor of the petitioners, you are also the owner of NK Patta number 9.
9 is the subject. 9 is the subject patta.
No, you were also the owner of
Yes,
9.
that I've stated in the.
Understood? You have not said that we seized and possessed. You have never said that you are the owner.
Para 2, मतलब beginning.
Where?
33 of the writ petition. Petitioners
Are seized.
33 of the writ petition. And that is the Jamabandi. Page 33, Lordship will find the names of Bhagavan Chandra Sharma, Hare Krishna Sharma, Golok Chandra Sharma, Chandrakanta Sharma, and Surya Sharma.
So para 2 has said patta number 9. Besides patta number 9, there are 3 and
This is 33 pertains to
In
Patta
addition
number
to
9.
that, the petitioners claim that the petitioners' predecessor were also the owners of another plot of land covered by Patta number 9 of village Nees Sindhuri Gopa under Moza Sila Sindhuri Gopa at measuring 158 bighas 4 kathas 18 lechas. On 8/9/2009, when the petitioners obtained the certified copy of the Jamabandi of NK Patta number 9, they were shocked to learn that their names of the predecessors in interest were struck off in respect to a purported stealing case number 372/76 initiated under the provisions of the Assam Land Bracket Assam
On land holding side.
Some fixation of ceiling on land holding at
Some fixation of ceiling on land and holding at, comma, 1956. For short, the Act of 1956. Under such circumstances, the petitioner submitted an RTI application relating, seeking, in relation to, seeking information pertaining to the sealing proceedings. On 27/2010, the petitioners were furnished with a reply along with certain documents. From the documents, the petitioners discovered that two sealing cases bearing sealing case number 384/1974 and sealing case number 372/1976 had been initiated against the original patadars in respect of the land covered by three pattas, being NK patta number 2, 3, and 9. It was also learned from those documents that the additional deputy commissioner, by its order dated 31/7/1974, passed in sealing case number 384/1974, had directed publication of the draft statement purportedly under section 7(2) of the Act of 1956. However, the draft statement, however, as to whether the said draft statement was at all published or not, the petitioner could not gather from the information so furnished. However, it is also, the petitioners could also come to learn that in spite of such directions in the order dated 31/7/1974, the proceedings in sealing case number 384/1974 were not carried forward, and instead, a fresh proceedings in the form of sealing case number 372/1976 was commenced, wherein the collector passed an order on 21/2/1976, observing that although the draft statement was published in the year 1970, no notices were served on the patadar, and thus the collector fixed the matter for filing of objections on 2/3/1976. It was seen that on 2/3/1976, one of the patadars, that is late Hare Krishna Sharma, had filed an objection by stating therein that there were 6 shareholders over the land in question, and as such, as per the Act of 1956, they were entitled for retaining 300 bighas of land out of the total lands. 300 bighas of it was also seen that late Hare Krishna Sharma also expressed preference to retain the entire land in NK Patta number 9 and 120 bighas from the other two pattas, being NK Patta number 2 and 3 of village Pataraj and Bonmoza respectively. Subsequent thereto, on 19/6/1976, an order was passed by the collector to the effect that a total of 310 bighas, that out of the total land of 560 bighas, a total of 310 bighas was liable to be acquired under the Act of 1956, and the remaining 250 bighas be allowed to be retained by the petitioner, by the predecessor of the petitioner. However, in the said order, there was no specification, in which dags or pattas such land was to be retained. The petitioners, from the documents so furnished as well as from inquiry, could not find out as to whether the final statement which is required to be issued in terms with section 7.3, 7.3, na? Yes. 7.3 of the Act of 1956 was at all.
7.5.
No, no, 7.3, na?
A draft statement is 7.
A draft statement.
7.3,
7.3.
7.3, that
Application is
Yes.
later.
depends upon the
As to whether the draft statement, the final statement was prepared in terms with the order dated 1976 and was published in terms with section 7.5 of the Act of 1976. The petitioners further had stated in their writ petition that along with the documents so furnished, there was also a document furnished of pertaining to the certificate of receipt of possession, depicting delivery of possession of the ceiling surplus land in NK Patta number 2 and 3, and has been shown to have been endorsed by the original Pattadas on 12/5/1981. However, most surprisingly, in the said document, the signatures of late Bhagavan Chandra Sharma was appeared, though the said person had expired in the year 1978 itself. The petitioners, I'm coming to learn about these gross anomaly, and also further that without the publication of the final statement, no right would vest upon the state. Filed an appeal, filed a appeal, na? It's an appeal or what?
There's application.
Filed an application in terms with section 7.6 of the Act of 1956 to the Minister Revenue, Minister of Revenue, Government of Assam, on 16/10/2009, making a prayer for setting aside the final statements. But there is no final statement. Then why are you asking for setting aside of final statement?
But they produce that as fine.
What did they produce?
That thing is 7.
Filed an application for review for setting aside, filed an application before a year under 76 of the Act of 1970. The same application for review, application was, however, dismissed. No, the same application remained pending and no action was taken by the government of Assam, no action was taken by the authorities under the Act of 1956. Under such circumstances, the petitioner filed a writ petition being WPC number 245 of 2009, before the score was by an order dated 21/2012, the coordinate bench of the score, coordinate single passed an order thereby directing the Principal Secretary Revenue Department to dispose of the application filed by the petitioner under Section 7(6) of the Act in accordance with law and within a period of 3 months. The record further reveals that on 26/2013, the Commissioner and Secretary, Revenue and Disaster Management Department, rejected the application filed under Section 7(6) of the Act of 1956 by holding inter alia that the time limit for preparing the application under Section 7(6) of the Act had already expired. This resulted in the petitioner again approaching this court by filing another writ petition.
Then I approach.
Filing a review application before whom?
Commissioner Secretary.
Commissioner and Secretary. Before the Commissioner and Secretary, Revenue and Disaster Management Department. The record, it is also seen from the records that the Commissioner and Secretary, Revenue Department on 29/9/2014 passed an order in the review application. The observations made in the observation, the findings arrived at in the said order being relevant are relevant, and as such, the same are mentioned, the same is quoted herein under. It will be page where that
Not 21 onward.
why do I do want the quoting of the entire judgment order?
No.
Don't
So therefore, I
give so-
summarize it as point.
Don't give so much importance to the commissioners. Will hit on chicken. 124 or black gold letters on the heart, in my opinion. From a perusal of the above quoted portion of the order, it reveals that the highest authority of the Revenue and Disaster Management Department of the Government of Assam categorically held, number one, the objections filed by the original Pattadas on 2/3/1976 were not taken into consideration while finalizing the statement under Section 7(3) of the Act of 1956. Number two, there was no record in the concerned LA proceedings to prove that a copy of the final statement was published or that the same was served on the Pattadas as stipulated in the Act of 1976. Number three, the authenticity of the document of handing over of possession appears to be doubtful since one of the Pattadas whose signature appears in the certificate dated 12/5/1981 had already expired on 12/8/1978. Number four, no schedule of land to be acquired or the land allowed to be retained was mentioned in the order sheet. Next. Irrespective of the said findings, as well as the observations so made by the Commissioner and Secretary to the Government of the Commissioner and Secretary, Department of Revenue and Disaster Management Department of the Government of Assam, the Additional Chief Secretary submitted before the Minister of the Revenue for approval that though there were irregularities, but a case for review was not made out. And as such, it was suggested that the review application be rejected. The said proposal was accepted by the Minister of Revenue. Under such circumstances, the instant writ petition was filed. Mr. BT, pursuant to the filing of the instant writ petition, notice was issued. The Deputy Secretary to the Government of Assam Revenue and Disaster Management Department filed an affidavit in opposition on behalf of the respondent number one. Stated that as per the report of the circle officer, North Guwahati Revenue Circle in sealing case number 375/1076. What is this 1076? He did it in the first century, what? 10th century, 11th century,
I was applicant.
1976. So one place, only one document is there. That is also a mistake. Yes, 1976. Under 7.3, order of the collector on 12/6/1976, the entire land of NK Patta number 9, measuring 158 bighas, 4 katha, 18 lechas, was acquired as per sealing law, and the land was converted to Sarkari. Other than the said statement, there is no other statement made in the said affidavit, save and except denying to various statements made in the petition. It is further seen that pursuant to orders passed by this court on 24/5/2023 and 14/6/2023, an additional affidavit has been filed by the we did Olokananda Medi.
Deputy Secretary, he's the Deputy Secretary.
So it doesn't he require to write that I am the Deputy Secretary. An additional affidavit has been filed on behalf of the respondent number one, bringing on record the circle officer's report dated 16/11/2009. The record also shows that there is another affidavit filed by the respondent number 4 pursuant to an order passed by this court on 5/10/2023, wherein it was mentioned that the district commissioner, Aminga, have been trying their best to trace out the original case records with utmost effort, but till date the same could not be traced. Further to that, the respondent number 4 had filed recently another affidavit on 18/6/2024. Nothing much substantial have been mentioned, save and except that in the order, that in the chitta, there is a mention pertaining to NK Patta number 9, that an area at measuring 158 bighas, 4 katha 18 lechas was acquired under the Sealing Act on the basis of an order passed by the collector on 22/6/1976 under Section 7(3) of the Sealing Act. Full stop. However, the said order have not been placed on record, nor the records of the said proceedings, being sealing case number 375/1976, have been placed before this court. In addition to that, it has also been mentioned in the said affidavit that the records of sealing case number 372/76 could not be traced out. It is further seen that replies have also been filed by the petitioners to various of the affidavits, reiterating their contentions made in the writ petition. Mr. B.T. Decker, the learned counsel appearing on behalf of the petitioner, submitted that the fact that the predecessor of the petitioner had rights over NK Patta number 3, 2, 3, and 9 cannot be denied by the respondents, taking into account their own stand that they have resorted to certain proceedings under the fixation under the Act of 1956. They, however, submitted that it is only on the basis of a final statement signed the vesting of rights would take place in terms with Section 7(4) of the Act of 1956. The respondent have taken a very the respondents, being the custodian of the records, cannot take a plea that we don't have the records, and as such, the rights of the petitioners in respect to the predecessor, the rights of the petitioners in respect to the lands in question now vest upon the state. Referring to Article 300A of the Constitution, the learned counsel submitted that the, the constitutional mandate to deprive a person of a property is only by in the manner it has to be in accordance with law. As there is no final statement, the rights of the predecessor of in interest of the plaintiff of the petitioner as well as the petitioner over the lands in dark number in Pata number NK 2, 3, and 9 could not have been appropriated by the state, and that too in the manner sought to have been done. The learned counsel, further referring to the order passed by the Commissioner and Secretary, Government of Assam, Revenue and Disaster Management, submitted that the order speaks for itself, that in the proceedings in land ceiling case number 372/1976, wherein an order was passed on 19/7/1976, though it was mentioned therein that out of the 560 bighas, 310 bighas would be acquired under the Land Ceiling Act, under the Act of 1956, thereby permitting the predecessor in interest of the petitioners to retain 250 bighas. But it is the mandate of law that such how much land how much land is to be retained in a mandate of law, where the land is to be acquired from where the land is to be acquired, and in which does the lands have to be retained, have to be incorporated in the final statement. Incorporated in the draft statement as well as also in the final statement. The same having not been done, the government would not have taken any rights, could not have acquired any rights over the lands belonging to the predecessor in interest of the petitioners, of the petitioners. In as much as Section 7(4) of the Act of 1956 cannot be made applicable. Anything more? I would not say about 180. You are entitled to 560. I have 560. Donate some to the CM's relief fund. Welcome. Mr. R. Bopugari, the learned counsel appearing on behalf of the respondent state, appearing on behalf of the revenue department, submitted that the petitioners hearing are claiming on the basis of a ceiling case number 372/1976 and 375. 372 is 384. 372 is 1974, 76, and 384 is
1974.
74. However, the land in which it was taken, land which is the subject matter of the writ petition in NK Patta number 9, was taken in connection with ceiling case number 375 in 1976. He submitted that though in the orders so placed by the learned counsel appearing on behalf of the petitioner, more particularly in ceiling case number 372 and 384, there is no mention as to how much land is to be retained and how much land is to be acquired. It was allowed to be retained and how much land was to be acquired. But in the order so passed in sealing case number 375 of the 1976, it was specifically mentioned that the land admitting 158 bighas, 4 kathas, so and so,
158 bigha, 4 katha, 18 lesser.
18 lesser, in NK Patta number 9 was acquired.
Yes.
Meaning thereby the entire land of NK Patta number 9 was acquired. He therefore submitted that as the instant proceedings pertains to NK Patta number 9, and there is a direction being sought for respect thereof, such directions cannot be issued in view of the categorical orders being passed in the sealing case number 375 of the 1976. Isn't it? Anything more? Let me come back. From this court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials from the court. From the submissions so made,
With respect of the mathematics, they say that they are in occupation. You say that they are not in occupation. Yes. Right. So it may observe otherwise.
from the materials from the materials and reports, as well as hearing the learned counsel, 3 points for determination arises for consideration. Whether the review application, whether the state government was justified in dismissing the review application. Number 2, whether there was any acquisition, whether there was any vesting of rights in respect to the lands of the petitioners in comprised in NK Patta number 2, 3, and 9 upon the state government in terms with section 7(4) of the Act of 1956. Number 3, whether what orders are required to be passed, what direction or directions are required to be passed in the facts and circumstances of the case. For deciding the point for determination number 1, it is relevant to take note of that the Act of 1956 was enacted to impose limits on the amount of land that may be held by a person. Section 2 of the Act of 1956 stipulates the exceptions, meaning thereby that the area, that lands which would not fall within the ambit of the said Act of 1956. Section 4 deals with the ceiling pertaining to the existing holding. And a perusal thereof reveals that the ceiling is 50 bighas in aggregate. And this limit of 50 bighas shall be applicable to the aggregate of the land held individually by the members of the family or jointly or by some or all of the members of such family. Section 5 deals with the requirement of submission of return by the person holding land in excess of the ceiling. The submission of the returns are to be filed in the manner stipulated in Form A1, in Form A of the Assam fixation of ceiling on landholding rules 1957.
Rule 3 says,
Upon such return being filed, as required under Section 5 of the Act of 1906, the collector may obtain the information required to be shown in the return through such agency as may be prescribed and select the plot or plots of land which such person is entitled to retain under the provisions of the Act of 1956 and also the plot or plots which are in excess. This aspect of the matter assumes importance taking into account that there is a statutory obligation cast upon the collector to identify the plots which are required to be retained and as well as identify the plots which are in excess. Inasmuch this is of vital importance taking into account that the draft statement to be prepared under Section 7.1 is to be made on the basis of the return as well as the identification of the lands which are to be retained as well as the lands which are in excess. Section 7 further gives an opportunity to the person to make objections when a draft statement is published. From the materials on record, it reveals that a draft statement was published and late Hare Krishna Sharma, Hare Krishna, sure. had submitted an objection. And on the basis thereof, the order was passed on 19/7/1976. This order of 19/7/1976 in sealing case number 372/1976 can be said to be the order to be passed in terms with section 7(3) of the Act of 1956. However, it is of vital importance that in order to vest the land which is in excess upon the state, there is a requirement of making of the final statement. In as much as without the final statement and in spite of the order passed, there can be no vesting. This assumes further importance taking into account that it is in the final statement. It would be duly recorded which are the lands which are to be retained and which are the lands which, being in excess, are to be then vested upon the state. The right to challenge such an order, right to challenge the order as well as the final statement the right to challenge to a person aggrieved is provided in section 7(6) of the Act of 1956. The said section being relevant for the purpose of the point for determination, for the instant point for determination, is reproduced hereunder. It was a reading of the same section, subsection, would show that a power has been conferred upon the state government to suo motu take up a matter pursuant to the final order and the final statement being passed. Or an application can be filed by a person aggrieved within 1 year from the date of publication of the final statement under section 4, or from the date on which the Assam Fixation of Sealing on Landholdings Amendment Act 1993 came into force, whichever is later. From a perusal of the said order, from the perusal of the said subsection, it further transpires that the power which can be exercised is the power of revision. Which, be it as it may, the right to file an application under section 7(6) would only accrue upon the issuance of the final statement. Inasmuch as it is on account of the issuance of the final statement, the excess area of the land would vest upon the state. From the materials on record as well as the submissions made by the learned counsels appearing on behalf of the parties, more particularly, the learned counsel appearing on behalf of the respondents, nothing could be shown as to when the final statement was published in pertaining to land acquisition sealing case number 384/74, 372/1976, as well as 375 of 1976. Under such circumstances, when the very final statement was not issued, and on the other hand, the lands have been shown, lands belonging to the petitioners have been shown to be ceiling surplus, to be government lands. It is the opinion of this court that the initial order passed on 26/2013, by which the application which was filed under Section 7(6) of the Act of 1956 was rejected, as well as the order dated 19/5/2015, whereby the review petition was dismissed on the ground of being delayed and barred, does not arise, could not have been passed. Inasmuch as without a final statement, the limitation for filing an application under Section 7(6) does not commence. This therefore answers the first point for determination. In addition to that, this court also finds it very relevant to take into account that the rights in respect to the lands in question belonging to the petitioners are constitutional rights under Article 300A of the Constitution, and as held by the Supreme Court in the case of Vidya Devi versus State of Himachal Pradesh, reported in 2022 SCC 569, the said right is akin to a human right. Similar observations can also be seen in the recent judgment of the Supreme Court in the case of Kolkata Municipal Corporation versus Bimal Kumar Ghosh, reported in 2020. Bimal Kumar Shah, reported in 2024 SCC Online, wherein the Supreme Court had categorically observed that the rights under Article 300A observe that the influence, full stop. Under such circumstances, the question of extinguishment of the right, which have not been acquired in accordance with law, does not arise, for which the authorities concerned ought not to have dismissed the application filed under Section 7(6) on the ground of delay. This brings this court to the second point for determination. As to whether there has been any vesting of the rights in respect to the lands comprised in Dagnam and Antipatta number 2, 3, and 9 upon the state government in terms with Section 7(4) of the Act of 1956. The parties before this court, including the Revenue Department of the Government of Assam, have placed before this court an order dated 19/7/1976, passed by the collector, which can be said to be an order passed under Section 7(3) of the Act of 1956. The said order do not show which of the land that the said order was passed in respect to land ceiling case number 372/1976. The said order does not though mentions 560 that out of the 560 bighas, 310 bighas was identified as excess land, and 250 bighas was allowed to be retained. But there is no mention whatsoever in which areas the lands have been acquired, have been retained, have been allowed to be retained, and in which area the land has been being in excess, have been acquired. This aspect of the matter would have come to light had there been any final statement. This court further takes note of that the Revenue Department have failed to produce any document pertaining to ceiling case number 375 of the 1976. Although emphasis have been laid in one of the additional affidavits filed by the respondent number 4, that the area of 158 bighas 4 kathas, 10 lachans were identified in pertaining to the MK Patta number 9 was identified as the land in excess. However, without there being any order passed under Section 7(3) or the final statement, which has not yet been published, without any final statement, the vesting of the rights upon the state can it be said that there would be vesting of rights upon the state? For that purpose, this court finds it relevant to reproduce Section 7(4) of the Act of 1956, which is here in under. A perusal of the said section say that irrespective of publication made under Section 7(5) of the final statement, but upon making of the final statement, the land vests upon the land, the excess land all rights, title, and interests of the person or persons in respect to the excess land vests upon the state. However, as there is no final statement, this court, no final statement, it is the opinion of this court that there can be no vesting of any rights upon the state in spite of the order being passed on 19/7/1976, holding that 310 bighas out of 560 bighas were found to be in excess. Under such circumstances, the second point for determination stands answered. In the backdrop of the above discussions, let this court now take up the third point for determination as to what order or orders are required to be passed. Taking into account that the review application was dismissed, taking into account that the application under section 7(6) was dismissed in a manner contrary to the provisions of the Act of 1956. And further, there being no vesting of the rights in respect to the lands, in view of there being no final statement in terms of section 7(4) of the Act of 1956. This court is of the opinion that the petitioners would be entitled to the petitioners would continue to continue to retain ownership. Continue. The petitioners herein will continue to remain the owners of the land in tag number in patta number NK in NK patta number 2 area of an area comprising of so and so NK patta number 3 of an area comprising of so and so, as well as NK patta number 9 of an area of so and so. Till appropriate actions are not taken in accordance with the Act of 1956. All rights. This court further finds it. It is also relevant to take note of the submission of Mr. Arbol Puzari, the learned counsel appearing on behalf of the Revenue Department, that certain rights have been vested upon certain persons on the basis of the sealing proceedings. Taking into account that there was no vesting of the rights upon the state by virtue of section 7(4) of the Act of 1956, the state would not have transferred, alienated, allotted, settled, or alienated any portion thereof to any other person. According, under such in that view of the matter, such transfers, in the opinion of this court, would be nothing but a nullity in the eyes of law. Accordingly, the instant writ petition stands disposed of with the following observations and directions. So, the impute order dated 26/2013, as well as the order of rejection dated rejection of the review dated 31/12/2009, 19/10/2015 are set aside and quashed. The petitioners herein would continue to remain owners of the lands comprised of the following area to be taken. Till such time, actions are not taken in terms with the Act of 1956. Number two, no rights to transfer on the basis of the sealing cases number 372 oblique, on basis of 384 oblique 1974, sealing case number 375 oblique 1976, and 372 oblique 1976. In respect to the lands of the petitioners upon the state by virtue of section 74 of the Act of 1976. Any rights on the basis of the above proceedings created upon any other persons by the state would be a nullity in the eyes of law. Taking into account the statutory mandate of the Act of 1956, the observations so made herein shall not, the observations and findings, the observations made herein, as well as the findings, shall not preclude the state from taking action in terms with the Act of 1976 and the rules framed therein under.
Speaking for the correction of record,
The revenue authorities are further directed to correct the revenue records within 30 days from the date of a certified copy of the judgment served upon the number.
so where your lordship has said that there will be a liberty not be precluded to initiate proceedings under 56. Your lordship had if permissible under law. If permissible, if otherwise permissible under. So why I say so, Lord, I had urged again another ground where these lands were already classified as town lands. So they may not perhaps come within the definition of. I can take over.
So, they could not have been a better order.
The learned counsel, appearing on behalf of the applicants in the instant proceeding, submits that the applicants herein are the tenants of the petitioners, the predecessor of the petitioner. And they have rights under the provisions of the Assam Temporarily Settled Areas Tenancy Act.
But they've not said
Taking
that.
into account provisions of the Act of the 1971, taking into account the provisions of the Act of 1971, the learned counsel submits that the applicants should be well advised to file appropriate application if finished at the
What admission I can prove?
not it's there.
And so, like,
Of like,
Yes, what is this? Yes. What problem are you going to cause here?
I don't it's regarding my excessive billing. The
Excessive billing.
My lord, the usual normal bill, my lord, the gentleman was paying was between 400, 600 and 1,000, and all of a sudden, my lord, the bill was rate of 81,000 or 51,000 plus. Then, my lord, the representation was made, and they, my lord, they reduced it to 51,000 and all.
Huh?
51,000.
How much is the amount?
Now, my lord,
You gotta stay. You've got to stay.
there is a state, my lord, saying that I'll be paying the current bills for that time.
Yes. And how much is the demand?
Now, my lord, in fact, the bills they have varied from time to time, my lord. If your lordship kindly comes to page 20.
How much is the demand?
They have not made any demand as such, my lord, except these bills, my lord.
So what are you challenging?
My lord, the bills, my lord, I am challenging. Those are at page 22 and 23.
Setting aside the bill number so and so dated 9/2/2000 amounting to 81,000 in one. You got to state. And any more bills?
Subsequently, my lord, they have raised bills after the matter filing of the case and filing of the affidavit, my lord. They have been raising bills of rupees 9,000 per month, almost. My lord.
Much? 9,000.
Whereas that is the way, my lord, they want to enjoy the entire amount.
What is the basis, Mr. Sharma?
My lord, after the stay was given, it was said that only the current bill will be paid. And accordingly, the current bill has been issued to them. Where in every of the bill, there is a reflection of the area.
It will always be paid.
Yeah.
Otherwise, you
Go to
will
the,
have a problem.
so my lord, this is, the lordship, entire contention of the petitioner is regarding that the bill which have been raised by us, this is a default bill. So my lord, there's a factual aspects that has to be decided. So therefore,
127.
so my lord, in a similar, this court itself, in Kalpana Sutradhar had referred the matter to the CGRA. So my lord, this matter.
Oh, yes, yes. Yes, we are not going there.
My lord, your worship will see what will stand there, my lord.
We can do one thing, Mr. Chaudhary. If you want to do it, I will do it. I'll hear it for 15 days on day-to-day basis. And at last, you will be tired at last that let us go to see. Go there. But now this 60,000, go there, get it done out there.
My lord, before that, my lord, before that, your worship will kindly see the stand there, take it.
Wherever there, anything out
My
there,
lord,
go
they
there.
say, my lord, that was a faulty meter reading.
We will look into it. We'll have it on day-to-day basis for 15 minutes. Every day I will hear the matter for 5 minutes. Think about it. At the end of the day, the client may have to pay more to you than the
My lord, the gentleman is 93 years old, my lord, they retired by
Yes,
my lord, good teacher. And they have
He
admitted,
has
my-
sons, daughters.
he has got a, my lord, widow daughter-in-law. And, my lord, they did well.
We'll look into it. Go there. What is this? Be payable this amount or not? They will look into it.
My lord, that's why, before that, my lord, your lordship, besides your lordship will kindly see there.
Client demand adjusted 23,000 to 51,000. Why do you say that it is more? How did you, one fine morning or why did it become 74,000?
Yes, well, that explanation, your lordship is there in the
That,
affidavit.
that irregularity is there, for section 126, they should have, there's something should have been done. But this assessment was not done. That irregularity is there, my lord.
Then you set aside.
Yes, my lord, that can be said, because, on one fine day.
Then how do you do it then? If I set aside, what's the
So, my
next?
lord, actually, because the entire process is regarding the bill and the meter being there. And then there was an inspection that had to be conducted as per Lord's order. An inspection was conducted and thereafter the affidavit was found. It was found that there are many other premises there, and from that the bill has been running. Which the petitioner has replied that for that is another meter. Then again goes to the factual aspect. So that is why I was saying that as per Kalpana Sutradhar, the matter will be referred to CGRL. And until then, he may be paid the current bill. And if there is no assessment done on the
But why did it become so much one fine?
That explanation is there in the affidavit, my lord, in paragraph 4.
Let us.
Paragraph 4, my lord.
You do one thing, the judicial delay, he will pay 50,000 to you. Don't worry. You pay a 1 lakh as cost to him.
My lord.
It is not you, the petition. For troubling a 90-year-old people. Like it. Goodness. This is the additional affidavit.
Once the affidavit is
Additional affidavit actually, you are mentioning about those bids, taking into account he is showing the areas.
Yes.
That ADR amount is being shown. That is no problem with it. That is not an issue, but the main problem is, yeah, let us be careful with what do they say.
But these are, it is because of erroneous,
We can accumulate the reading of 9 but it does the only simple man. Which was substituting.
मतलब these said मतलब that was there was a erroneous मतलब meter reading and very good.
Therefore, they say we have corrected. Now, so therefore they are doing.
Then they also say
After adjustment of 976, the consumption for the period from Oman as reflected in the bill is 12,000 square meters. Only reflected in the bill for period from Suez. How many units were shown for this period for 1 year? From 1/3/2010 to 7/3/2021.
We have given a chart, my lord. That in the affidavit in reply at page 5, my lord, we have given a chart. Page 5.
Why there is no bill for this period after 27/3/2000 year to thereafter?
हमारा 20th of September 2021, that was the month of last bill. Thereafter, we approved some of it.
No. Prior to that, in between, kindly say from 27/4 to 2020 to 12/3/2020. Thereafter, 8/11/2020. Was it because of the COVID?
No, he did not have those money. He could not locate those money.
Was it due to the COVID? Maybe there were some relaxations.
No, madam, they were online bill was, online the bill was issued to everyone.
So later on, you came to learn that this was actually the consumption is high.
Yes, ma'am. And accordingly, madam, was we adjusted. That is what we have said in affidavit. So it goes down to the fact other than 126.
So then you found out that there was some defect in the meeting,
Yes, ma'am.
and as such, on the basis of 976.
It was wrongly reflected in the bill.
Now, every month, how much is the units being shown? Somewhere it must be there, yeah. It's shown now. These are the bills, na? Recent bill, page 52.
17 December, my lord, of the additional affidavit, page 11.
Bill
7.
Current charge is 242, madam. Page 11, you have also fine. Sorry, my current. So,
Current demand is 532 money. 532, it's in the, it's a TDC bill, my lord, temporary disconnection bill. That is at current demand, that is at top, 532. And the previous, and the meter reading details is at the first line. Previous reading in KWH 14047
Which page you are referring?
My lord, annexure two of the additional affidavit in reply.
Activity in reply.
Yes, my lord.
Where is it?
My lord, at the top, my lord, meter reading details, my lord. Previous reading in KWH 14047, current reading in KWH 14047.
The meter is not working.
So therefore, thereafter, my lord, billing details 532, outstanding
Previous
amount,
reading, 14047. The
previous
current
reading,
reading is. You know,
then the current demand is 532.
no, here you are putting zero. No, this can't be this, the bill. This can't be the problem. Here, I think it will page 94, page 10, you will get it. Okay? Page 10. Yes, units comes down. 112. 112 units. Kindly see page 9 of
Yes, my lord, page 10, my lord.
units 112. So these are all 112 units. Per unit is how much? 7.2. And with fixed charges and all.
7.2 is the per unit charge.
So now earlier, how much was the unit shown?
After there is writ petition.
Hello. They were disposed of the ground of non-maintained.
My lord, at annexure one, my lord.
So how did you arrive at this 51,000?
My lord, as per the affidavit and as per the instruction that I have received, the meter reading was taken wrongly. And as the meter reading was taken wrongly, there are,
For last 12 months you.
yes. So thereafter, the meter reader was terminated from his service, and thereafter the actual reading was taken. And after the actual reading was taken, thereby the adjustment was made. And after the adjustment was made, it was mentioned as an area in all the bills. Because by that time,
You were given 1,500 rupees installment.
yes, and he had agreed to it. He has agreed to it. He had paid by 6/9/2021. He had been paying it. Thereafter, he approves the court. The court directed that the area amount has not to be paid. The current bill has to be paid. Thereafter, court directed us for an inspection. After inspection, we filed an affidavit where our stand remains the same, that there was a meter reading that was been shown, that was been broken. So it all goes to the factual aspect.
So as per your thing, what happens if the meter is bad?
If there's a defective matter, my lord, that is bid that is replaced.
Okay, but how do you adjust it? How do you recover the earlier period? First of all, it is your duty.
Yes, my lord.
Look into the meter was that.
Yes, right.
Sorry, mistake has been done by your person.
Yes.
Because of that, this is. So what, if I am not wrong, as I see that your particular book of there, it says that last 12 months thing is being taken.
Yes, last 12 months.
Average is being taken on the basis of the present. Isn't it?
Yes, it's a basically,
And that difference which is there, you are asked them to pay.
yes,
How the manage.
basically an as a average assumption unit that we take into the aspect and then
So, Mr. Chaudhary, what to do?
Things, on the average bill,
No, it has been
it
replaced.
has not been.
Huh?
It has not been.
my lord,
There was no defect in the meter.
yes,
The
they,
defect was with the person.
yes,
So thereafter,
that is what we are,
Person has been terminated.
in the affidavit, they also say about defect, I know.
No, the affidavit, they say the meter reading was wrong. Kindly see paragraph 5. Install in the so and so erroneous meter readings of an outsourced meter reader. This is what has happened. They had outsourced it to somebody else, so he made all these box. And now, when they thereafter when they find out Oh, all of a sudden, how did this happen? There must be, this is the difference. And these are all MDI meters.
Yes, my lord.
Then you have a particular manner in which you do it, na?
Yes. These are the old meters where the chip kind of a thing. My lord,
Given an installment you have to pay.
being fair to the court, my lord, I think Kalpana Sutra will help him. Will help the petitioner, my lord, because
Better do the everyone is waiting in line. Asking.
Then Mr. Shah. Next week. Otherwise, what they have given, I think, given 1,500 rupees excess. This is what has happened because one fine day, these meters being electronic meter, this is not a case of meter being wrong. The outsourced meter reader, he did not record it properly. And when the proper person goes and records it, then he finds a big difference. From it. Just for example, this person was showing from 1 to 100, the other person found it 1 to 1,000. So this is the 900 which is left. So they therefore added this. Isn't it?
yes, my lord. And as for 556 2, we have to show it as a area bill in all the bills.
That's the
Otherwise,
requirement.
that's the requirement.
But what about the surcharge? And you are giving him an installment.
Yes.
Then
No, no.
why are you imposing the surcharge?
No, the area bill, the area bill, I don't know, just see the bills. my lord. The surcharge is zero money. Current charges is zero. Of my affidavit of position at page 6.
Lordship kindly sees my lord, my delivering in reply. But this raises a minor doubt because the meter is not, meter reading is not there. So lordship kindly comes to page 11 by the
How?
reply. There, my lord, the meter, previous meter reading and my lord, current meter reading is same. And there also, my lord, charger is.
No. This is an area bill.
Area bill,
This is an area bill. Area bill does not have meter reading.
see bill, it's there.
When they give a bill, they have to put, therefore there is zero consumption. In so.
And my lord, the status of the meter can be seen in the top meter status level.
Hello. Okay. Yes, Mr. Chairman. To do.
Earlier bills are there, my lord, whatever, my lord,
You are already paying the 1,500. Next time they will give you in installments.
Whatever my lord is,
Don't impose penalty.
whatever my lord.
no installments regarding that one, also, those bills are to be made, those two bills from the that is defective or the defective meter reading, those bills are.
There is no defective meter reading. The meter reading has been wrongly made by that person. Bills will remain as it is. The question is you have to pay, but they will give you in installment without imposing penalty. That they have done it. We are giving you by 1,500. Or do they? That is, I passed an order.
Yes, Kalpana Sutra.
This is a very good forum to go there.
When?
Person does do the math and after time, that's 5:30. Yesterday I had one at 5:30.
Monday I will have a
It will matter on Tuesday again as the last item of the week. Three. Huh?
From other days, second half, I thought ticket.
Well,
Second half, any day, my lord, next. Any day next.
okay, the request of the learning. What is this additional affidavit?
And that matter suit has been filed, that is why he has filed it. He has filed a suit for declaration matter then, injunction.
That's Sayamala, you don't have it. So you want to vacate when? You have to vacate.
Any other thing.
This matter on 28th of November.
But
Wait, I'm not there.
26.
This thing. Oh, sorry. Okay. In time order after this.
In time will
It is. Yes, item 4, item 4. Huh? Yes, I'm right. Really. When do you want it? At 2? Okay, I'm not sitting it. Huh? When? What is this matter about?
but it's authorized, unauthorized. Not unauthorized. Is the party,
no party
on the basis of the NOC.
Okay, is this matter again on? No, it is not part of matter. This is matter again on 3rd of December. Yes. For 5 and 6. Five period. Huh?
Item number 6.
Yes, what is it? Why it has come up for orders? Payments? These items again on 5 to 8. Yes, I said items again on 27th of November. Yes. Next. Yes, Mr. Chaudhary, what are you doing here? No matter. Yes, this is a series. What is it? Pertaining to the what? Pertaining to?
Tribal wealth matter, when the transfer is illegal, void. Konapur, that area. There is an inquiry for the 2021. And they have not even challenged the order of the Board of Revenue. They have challenged the order of the Deputy Commissioner, which could merge with the Board of Revenue order of 16th March.
Where is the petition account? In fact, this matter earlier came up before me. One.
Yes, I think.
Then they got
Then we
it. This matter was sent. They were saying that matter is pending because of your existing counsel.
And then we thought.
He made it that let it go to the division bench because there is
Because
another
division bench
matter.
I got it remarkable.
Dispute portfolio of Via or whatever maybe there's another.
Yes, yes, we got it remanded from the division.
Yes, from there again now it has come back. So your case is under chapter 10.
Chapter 10, madam. If it operates, madam,
There can be no creation.
there cannot,
What
and
they
no
will-
equity can be claimed. No equity can be claimed, and madam, there are findings by the circle officer, the deputy commissioner, followed by the Board of Revenue, the concurrent finding. Notice will not set it as a supervision body.
It is against a good evening order.
Yes, and the order has not been challenged.
So what order is it they are coming against?
They have challenged the earlier order of the deputy commissioner of 6th September.
Under what provision?
That was under that order
Order passed under that 165,
165, yes, madam.
165 order.
And appeal lies before the Board of Revenue. Board of Revenue passed the order on 16th September. They said they came in this writ petition. They said that we have applied for the order is not ready. So we are challenging the deputy commissioner's order, which stood merged with the order of the Board of Revenue. And this court, my lord, in the interim order has stayed the order of the deputy commissioner, which is no longer in existence. The doctrine of merger is applied.
They have taken that as a ground in your affidavit.
Yes, yes. In fact, what happened was,
They have not
No.
opened up.
no, and they have not even placed the order. Order was placed by my friend NNB Chaudhary in this court. That this is the order which has come. They have not even challenged that order, amended the rate.
What is the government stand?
Government is supporting us. In fact, the deputy commissioner has filed a,
Well,
But-
supporting you, that is okay, but what is the government stand on this? What are they doing? They are otherwise very vigilant upon these things.
no, they
They
have
are
taken,
very vigilant.
they have done their job. My lord. So far as the deputy commissioner has also filed a affidavit before your lordship, saying that the gentleman on the basis of which they were claiming tribal status, but this is a partnership firm. They were saying one Mukul Lamare is a scheduled tribe. His certificate has been cancelled by the caste committee member. So the deputy commissioner said that he's not a recognized caste within tribe in Assam, in that area, or not within that notified tribe. And secondly, his certificate has been cancelled. Now what they have done is now they have amended the partnership, brought in some Ravas, and says now the Ravas have become the 100% partner in the firm.
So you give the rubbers and what happens, but ownership,
Nothing, yes, you can't, the transfer is void. The law says the transfer is void,
how can partnership transfer cannot happen like this?
but cannot be, in fact, not a new land policy.
In fact, in Assam, we have they want to transfer the land by way of changing the partnership. They can,
They cannot, in fact, the new land policy of 2019 says that in case of a partner, it can't be that you have a minority partner in the firm and then claim tribal status.
anyway, you cannot change the transfer. So they purchase the land at the partnership firm.
Yes. And the land which they are claiming, it's a very peculiar case. They are claiming under a plot of land which according to them is in Dag number 95. It's KP Patta number 30. Our Dag number is Dag number 30. These are two opposite sides, Bigaru, the banks of Bigaru. It's not even contiguous land. They are saying maybe some part of Dag number 30, 35 is also part of 95. That's what they are saying maybe. And yet, for 2021, there is an issue.
The advantage that it is 1 o'clock, the other side must have been.
The lordship take it up at 2.
Oh, too much. Yeah, I'm writing early. Some other day.
And I request of 5th December, Thursday.
I'm not there. You are there.
For the respondent number 11 for Punjab. For the respondent number 11,
Who is he?
the Punjab National.
In this bank.
Okay.
But they have taken a loan from me.
No, may I say this. The original parties before this authorities were till respondent number 5. They have now added Department of Industry and Commerce, District Industries and Commerce. They were not parties before the certificating authority.
The simple matter under 150, chapter 10 has
Yes.
now been brought into the
Can they do it?
getting permissions from all.
The writ petition, can they do it?
Then it is, why did you file an app? You must have filed an initiative the
Complaint
under
before the circle officer. Circle officer gave a report to the deputy commissioner. Deputy Commissioner gave hearing adjudicated and said that it is tribal land, the transfer is justice. Against which have been lies before the Board of Revenue. And Board of Revenue dismissed the, and these are concurrent findings. Process may give a date when what is convenient for your lordship.
I'm not there from 1 to 12, I'm not there. 13 times. You're there on 17th? Have it on 17th?
First item, your lordship, have a category of top of the board.
This matter needs to be finished.
Yes.
Every day they come up with this thing that I have not done the document.
And my lord, in fact, there's a division bench order which says if you don't file pleadings within this particular date, pleadings are closed. So that pleadings are closed now today. Whoever has filed, who has not filed, has not filed.
But how do you take care of a situation? Now, these are tribal bills. Now, how do you get them evicted?
The law says 165. That's what the deputy commissioner said. After the order, it was then issued a notice for eviction. There's a procedure.
Then, after that, what happens?
That they challenge, the entire thing they challenge, and your lordships have in the interim order has
So
stayed
they challenge the 165.
165 plus the original order. 3rd September and 6th September. 2021. 16th, 18th September. No,
So,
16th September.
how? With a 165 proceeding, initially now. Did they challenge the order passed in a 165 or a
That-
165 proceeding?
Once the order has been passed, eviction notice follows as a matter of course. So the order of the deputy commissioner has come saying that you are in illegal occupation. This transfer itself is void. Then they issue a notice that you vacate. Give them time. If you want to remove your structure, you remove your structure. That was the notice said. They challenged both before the Board of Revenue. Board of Revenue dismissed it. Now this court matter while
Yes,
granting.
Mr. Counsel, you have not challenged the Board of Revenue order
Well, have been instructed in this matter, your lordship.
to withdraw.
No, lordship, not
In what?
instructed regarding this particular aspect.
It is,
No,
it is,
Please have the prayer at page
it is
25.
put in golden letters out there in the affidavit also. Then, and you are not instructed, means very good.
Lordship, may I-
Without the final order of the Board of Revenue not been challenged
the
and
matter
they
may
have
come
not
about-
instructed you.
And
We
this-
should dismiss your
and
petition right away.
Let the matter become a 90.
What 90? Why?
If my senior had to leave court also get travels on the lordship. Senior had to-
You know, I don't grant this adjournment on senior advocates.
19 dollars.
Senior advocate, no adjournments. Ask for some other good girl. No, then you don't have. No, we vacate the order.
So 19 dollars.
Not 19. Vacate it. Why haven't you challenged the Board of Revenue's order? Ask your senior or whoever it is or change your senior and bring it on 17th of December. I'm taking it as the first item.
So it-
List this matter to sub this court. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petition. I've also heard Mr. A. Chaudhary, the learned senior counsel assisted by Ms. P. Chaudhary. Appearing on behalf of the private respondents, Mr. S. Dutta, the learned counsel appearing on behalf, senior counsel appearing on behalf of the Punjab and Punjab National Bank and Mr. A. Chaudhary, the learned senior counsel submitted that the instant proceedings is absolutely not maintainable, taking into account that the order passed by the Board of Revenue that maintainable in as much as the petitioners herein have assailed an order passed by the Deputy Commissioner. The instant proceedings, though the
3rd September 2021.
though
The order.
the petitioner had filed an appeal before the Assam Board of Revenue. And the Assam Board of Revenue had dismissed the said appeal by an order dated
16th September 2021.
16 September 2021. He submitted that this very aspect of the matter had already been brought on record by way of the pleadings. However, the petitioners have not assailed the same. In addition to that, the learned senior counsel has also submitted that there's also an order passed by the division bench that the pleadings were required to be filed within a particular period of time.
Dated 27 June 2023. We make it clear no further time will be granted for filing claims.
Also made it clear that there shall be no further time for filing of any pleadings. In that view of the matter, the learned senior counsel submitted this is a case where the writ petition ought to be dismissed at the threshold.
Plus, and a suppression of right with I.
Taking into account the submission made by the learned counsel appearing on behalf of the petitioner on that he has not properly read the brief. Matter to be further taken up on 17th of December. But in the, he can go to